Dear students, welcome back to IP Law HOE 6019. So today is the last lecture for trademarks law, and I plan to cover some aspects of trademarks that have not been explored so far. So we have looked at what are the requirements for registration of a trademark. We have looked at the various criteria that the trademark office follows, then the procedure for registration of a trademark, and how are all these related to each other. So far, so good. There are, of course, some other aspects as well, certification marks, collective marks, and these are from the notes. You can see that they have some subtle differences. But now, today, I would like to focus, being the last lecture for trademarks law at least, I would like to focus on what can you do with a trademark. So what are the rights of a trademark owner, or as they call him or her, a trademark proprietor? So today's lecture will be dedicated to aspects regarding post registration. And well, of course, if you get your trademark registered, now you get a certificate of registration. If you look in Moodle in the lecture notes, you'll also find some copies of a registration trademark and a certificate and how they look. So they're quite simple. You have the trademark details, then you have the name of the trademark owner, and then the address, the class. Remember, we spoke about the class, then the goods or services for which this particular trademark is registered, and the date, and of course, the seal of the trademark office. Now, once you get this registration done and you have paid all the money for it, you or your client, in that case, now comes the next procedure, which is renewing your trademark. And of course, as I had mentioned right in the beginning, your trademark has a validity period of 10 years, and after 10 years, you can renew it again. So now, why would you want to renew your trademark? Well, of course, if you're in the business and this is what you're doing, then it makes sense. But what if now, as I said, you can have a trademark and trademarks can last for hundreds of years. Now, let's say you're a car manufacturer, Ford, and you make cars, and one of your first most successful cars was the Ford Model T, which came in the 1914, 1915 period. And well, it was a good car, and then after about 10 years, 15 years, your company has now introduced the Ford Model A. That was in the 1920s, late 1920s, early 30s. And now, after all these years, you've been coming up with newer and newer models all the time. So today, Ford does not make the Ford Model T. Why would it want to keep on paying for renewing this trademark when it's not being used? Of course, maybe there are some historical societies, maybe there are some special events, maybe they make spare parts, maybe not. On the other hand, if you look at, say, Toyota Corolla, now this is a car that's been around since the 1960s, and I remember seeing it in the 1980s and 1990s, and of course it has changed over the period of time, but the the trademark remains the same, Corolla. So of course, if you are using your trademark, it makes perfect sense to keep on renewing it. But if you're not using it, then of course, there's no reason to keep on wasting money, and then you can let the trademark go. So there are some requirements about the costs for renewing a trademark, and all of these are of course very important and must be kept in mind. Now, what would happen if you don't renew a trademark? Well, then you can have a serious problem. Uh, Very early on during my professional career, I had this issue. I had a very big Swedish client, and I was working in a law firm, and I used to handle their matters exclusively. And then one fine day, the head of the IP department from that Swedish company sent an email to me saying, well, we gave you instructions to renew a trademark, and we have never heard about what happened after that. And I was like, I have no idea about this. I mean, I'm very meticulous. I keep a diary. I have all my records, and I don't remember any such conversation which I may have ignored. And then she sent me a scanned copy of a letter dated 1978. Yeah, I mean, come on, this is crazy, right? They obviously wrote to somebody in my law firm where I worked in 1978 to renew a trademark. And this person, I don't know what happened. I was born in 1975, so I was 3 years old at that time. How do I know what happened? Well, that's not the answer, of course, that you give to a client. So I said, well, okay, I'll look into this, and checked all the records. And it turned out that since 1978, nobody had renewed the trademark. And of course, now the trademark is it's gone. Because if you don't renew it, you lose the trademark. But for every problem, there's a solution. And of course, I told the client I'll take care of it. So we have been using the trademark, but we have not been renewing it. So we applied for a fresh registration of the same trademark. And in the trademark application, we claimed that we've been using it since the 1940s or something. And so it went through, all the procedure was there, we had all the evidence and everything. And of course, I even mentioned in the trademark office that this was already priorly registered, and then because of our mistake, this was not renewed. And luckily, nobody else had applied for the same trademark. So at the end of the process, we got the trademark re-registered with a new registration number, but claimed use since the 1940s. So win-win situation. Of course, we did not charge the client. So client is happy. We saved our reputation. Job well done. So the boss is happy. Well, everybody's happy. But of course, if you don't renew your trademark, you can get in serious trouble. So what can you do with your trademark? What can your client do now that the client has a trademark? Number one, of course, they can put R in a circle, and now they can show to the whole world that this trademark is registered in this particular country. You can license your trademark to somebody, and that's a process I'll talk about a bit in detail. You can sell your trademark. Of course, that's called assignment. And you can also sue others who use a trademark which is confusingly similar to yours, and which can cause confusion or deception in the course of trade. So these are some of the things I'll talk about today. And well, when you sell a trademark, of course, you have to be very careful here. A trademark can be quite different from your usual property. Now, this is a peculiarity of intellectual property law. So you can divide a trademark in the context of, for example, let's say you could, if you have a business in Estonia and Finland, and you have the same trademark, Stockman, then you could say, well, all right, the Finnish business I will sell to a Russian business office, business person, and the Estonian business I'll sell to an American business person. So of course you can take a same trademark and have a geographical limitation of sorts. Within Estonia also, you could say, all right, I have the trademark Kaubamaja, and I'm going to let X use it in Tallinn and Y use it in Tartu. So you can do all sorts of things. You can also break up and say that I have a trademark for fire extinguishers and fire extinguishing services. So it's the same trademark. And the manufacturing of the fire extinguishers, I will give it to somebody else, sell it off. And the aspect of taking care of the maintenance procedure, I'll give that to somebody else. So you can do all sorts of things, which is very different from, let's say, a pen like this. You see, when you sell this pen, you have to sell it in one piece. It doesn't make sense to make it into 10 different pieces. But for a trademark, you can cut it up into all sorts of packages that you think will get you more money, and you can sell them separately. So this is a peculiarity that you have to be careful about. Of course, when you have a trademark, it's not just the goods or the services, but there are other aspects about it as well. You have goodwill, which can be valued. And of course, this is a bit tricky because let's say you want to buy a Burberry jacket for 25,000 euros, and you could buy it from a kiosk in Baltiam, Kesturg or somewhere, or you could buy it from Stockman, the departmental store. And it's the same price, it's the same quality, everything is same. Where would you prefer to purchase it from? Well, now let's say you buy it from Stockman, something goes wrong, you can always go to the manager and say next day, hey, I bought this product and it's a high quality product, I paid a lot of money for it, and there's a defect in it. What will the manager tell you? Sit down, have a cup of coffee, we'll get this thing sorted out. you're a high end customer for us. Now that's goodwill. Contrast this with that kiosk and that babushka you bought this Burberry jacket from. You go to her next day and say there's a problem. Chances are, your problem may not get sorted out the way you like, and because there may not be adequate after sales service, as they call it in the jargon, trade jargon. So of course you have to be very careful about these things, and that is goodwill. So goodwill is something which brings customers back to you again and again. And again, that's the thing which would have a value to it. So if you want to buy Stockman, say the trademark or the company in Estonia, one way to measure the worth of this transaction would be to say, all right, well, the Stockman house is here and it's worth so much money, so that's what I'll pay. But on the other hand, you could also say, well, it has a reputation, it has a regular clientele, it has people from Estonia, from foreign countries who come here, and so based on that, it has another reputation to it. So the total value of this trademark would be the cost price of all the capital expenses, and then of course that would be the house, the car, the stock in trade, and all of those things, all the goods packages, whatever they have. And then you could say there's a separate price for the goodwill. And yes, when you sell a trademark, you could sell a trademark with goodwill or without goodwill. And one of the key examples of that would be this particular case that I have put up in Moodle, Elizabeth Emanuel trademark case. So it's a good idea to read it. And again, I have to stress over here, from the exam point of view, only whatever is mentioned specifically, study for the exam, is what will come for the exam. But all the other things are good to know. And in the Elizabeth Emanuel case, for example, there was this fashion designer and she made this wedding dress for Princess Diana for her wedding in the 1980s, early 1980s. And it was a big success. Princess Diana got married to Prince Charles, the future king and queen of Great Britain. The wedding of the century ended up in a bitter divorce, but that's life. So of course she made this dress and she made other dresses. So she became very popular. Her trademark became very popular. Her company became very popular. And the name of the company was Elizabeth Emanuel. So that was the name. And so after a few years, she decided to sell this business. She had a lot of tailors, seamstresses, designers working for her. And they were all selling their products under the trademark Elizabeth Emanuel, which happened to be also her name. And now she sold this trademark and the company and the business and the goodwill and everything for, I don't know, a sum of money. Let's say 100 million. So she sold those to X, and now after a few years, X sold this company with the goodwill and everything to Y. And so, well, that's how things are. Now, a few years later, Elizabeth Emanuel got a bit bored and she decided to set up a new company with her own name. And surprise, surprise, she wanted to start designing wedding gowns. So of course, Y, X and then Y. So Y was upset and said, hey, what the hell is this? We paid a lot of money for this company and you cannot now start a new company with the same name or trademark. But she said, it's my own name. So how can you stop me from using my own name? So when this matter went to court, you can see how this got problematic. And of course, the court said, no, you cannot start a new company with your name now because, there have been transactions and you have sold this company to somebody else and on to somebody else. And they have legitimate expectations, and you'll have to start a new company with a new name, not with the same old name. So that's about selling, assignment. Another important thing you can do with a trademark is you can license it. Now this is with all property, it's like whether it's movable or immovable. Let's say you have a flat, you own a flat, and now you want to build a house. Well, you could sell your flat and build a house. Or, you have an income, you have a flat. What you could do is you could go to the bank and you could say, well, I will use my flat as a security for a loan to buy a house. Yeah. And so that's one aspect, something I would like to do. And I will also give out my flat on rent. and the money I get from the rent, I will pay the bank loan, the mortgage charges per month. And so the 20-year loan, at the end of 20 years, your house is yours. The flat has been used to pay the installments of the mortgages every month. And at the end of 20 years, even the flat is yours. So it's a win-win situation. And that's, of course, licensing. And licensing is a very prestigious way of dealing with trademark issues, because it's a smart way of commercializing your IPR, especially your trademarks. And so you're not selling your trademark, but you're licensing it. And licensing, of course, can have some pitfalls. So one of the cases is the Bostitch case, and I have also put up some information here regarding what are the requirements for licensing agreements and what can go wrong and things like that. So you have to be very careful about this. So the Bostitch case is a very good illustrative case about the problems that can arise when you license a trademark. So the situation was, Bostitch was a US based company and they were making sewing machines. This was before World War II. And they decided to license the manufacturing and sales of the sewing machine to a company in the UK for the UK market. Remember, at that time UK had an empire, Great Britain, so they could sell it in different parts of their empire and things. So the American company gave a license to the British company and gave them the blueprints, the instructions and everything, and said, okay, well, you can start making sewing machines and selling them. And every sewing machine you sell, we get 20% of the price. Yeah. So that's a win-win situation. And things were going very well. And of course, then came World War II. And World War II was a very serious affair, lasted from 1939 to 1945. And there were a lot of problems, a lot of battles and things like that. And of course, there was a lack of communication between the US company and the British company. The US company got involved in the war effort. They were making machine guns and stuff, just like many other American companies. And so the British company continued to make sewing machines because, war or no war, people still need to wear clothes, repair clothes, mend clothes and things like that, and stitch them and etc. So at the end of the war, Second World War, so in 1946, 1947, the American guys were like, hey, we haven't heard much from the British people. I mean, we had this license agreement. They were giving us 20% for every machine they sold. So where are these guys now? I haven't heard from them. So the American chairperson of the company wrote to the British director and asked, what's going on? Hi, long time no see. Where's our money? And the British guy replied, well, now there's a problem here. The problem here is you haven't used the trademark, and we have been using it in UK, and of course the world has changed. World War II is over. The world is not the same anymore. There's a USSR, there are all of these things. And so now there's no Nazi Germany, no Japan, no Italy, none of the fascist states. So, well, customers now say that this trademark belongs to us. So they don't know who you are. We don't know who you are. We are a British company. We make British sewing machines, and our British customers think we own Bostitch. So bye-bye. So of course, this can be a illustration of all the problems that can arise when you license out something to somebody else. And it's the same like those of you who are living in Tallinn in a licensed flat. It's not your property, right? You just have a right to live there. And of course, you cannot remodel the bathroom or change the wallpaper or something. You just have the right to live there. And that's the same with the license agreement. You just have the right to live, to use the trademark. But there can always be problems if somebody misuses or steals the trademark. That's why when you have a license agreement or a registered use agreement, then you should always register them in the register of trademarks. And then, so these are all the requirements that come up. There is a sample of the register of trademarks in the Moodle course. And basically it's a register which is kept by all government trademark offices. And then it has the trademark, the name of the proprietor, the name of the address of the proprietor, the class, the goods or services, and then when was the trademark registered, when was it renewed, when was it licensed to somebody, when was it sold to somebody. So it's like a property register and all the details are there, and of course that is very helpful. One more thing you can do with licensing, of course, is franchising. Now this is a more advanced version of licensing, and I have some documentation put up over here as well, which can help you to understand how these things work out. And so when you're looking at a franchise agreement, so there's a franchise agreement between, let me see, well, okay, so it's here. I'll recheck this. And of course, when you have a franchise agreement, basically it's like when you're talking about, let's say McDonald's or Hesburger, okay, not Hesburger, maybe Subway, Burger King. These are not the original American companies based in the United States, which are now operating in Tallinn or in Finland, Helsinki or wherever. That would not be the case. Instead, what you have is a situation where you have a franchise agreement. So the US based franchisor is interested in setting up McDonald's in Tallinn. Now, they don't want to do it themselves because then they'll have to deal with property issues, employment issues, contracts, all sorts of things, language, everything. So instead, what they would prefer to do is appoint franchisees. So if I have money in Estonia, I could go to them and say, hey, I'm a businessman. I have 50,000 euros in the bank. I'm liquid. I have liquid cash. So I have no problems with money, and I want to start a restaurant business. And I could start, of course, my own, my own hamburger business. But it's better if I start a McDonald's franchise operation, because then I don't have to spend too much money on publicity and stuff. Everybody knows McDonald's USA, and they'll come automatically to me here. So that's a franchise agreement, and it would contain certain requirements. Number one, of course, I would need to have this outlet in a very good location in Tallinn, not in some dumpy place. Number two, upfront, I have to pay maybe 10,000 euros every month to McDonald's USA. Why? Well, license fees, royalty charges, they are giving me know-how, instructions, menu, blueprints, all those sort of things, how the restaurant should be, what the training should be for the employees, how the cooks should, prepare the food and stuff. So for that, I have to pay up 10,000 upfront every month, whether I sell or I don't sell any food. So that's clear. Another aspect of this franchise agreement would be that for every hamburger I sell, McDonald's gets a certain sum of money. So let's say if I sell a hamburger for 5 euros, and McDonald's would get 2 euros 50 cents straight away. I mean, that's their profit. So if I sell 10,000 burgers, they get the amount of money, 50%. Now, out of the remaining 2 euros 50 cents, let's say my actual costs for making this burger are 2 euros. There's bread, there's meat, and there are employee costs, there's a kitchen, I have to pay taxes, I have electricity, rentals, whatever. So now my profit is 50 cents. All right. So the burger costs 5 euros, 2 euros 50 went to McDonald's. 2 euros was the actual cost of making the burger, and 50 cents is now my profit per burger. So if I sell 1 million burgers, well then, so I get that 50 cents profit per burger over the period of time, over 1 year. Now, as a businessman, if I would like to really increase my profit margin, now here's a problem, right? I mean, 2 euros 50 goes to McDonald's USA. I can't do anything about that. So all that I can do is mess around with quality. I could hire some cheaper chefs, people, pay them less money, college students, part-time workers, whatever. Secondly, well, chicken burger doesn't need to actually comprise of chicken 100%, right? I mean, it could comprise of a few other things also. So, you come across these scandals all the time. If you have horse meat and you put some horse meat in the food, who will know? A little horse meat won't kill anybody, and it's a lot cheaper than other meat. And if you just put in 10%, nobody would ever know. So that's a sort of issue that can arise, which a franchisor has to be very careful about. Similarly, Subway has this foot long, foot would mean 12 inches. And so that's your foot long burger. And then somebody actually went and took a measuring tape and measured the burger, and it was 11 inches. So what's the big deal? It's just 1 inch, right? Maybe while heating it shrunk or something. Well, no. Now imagine if this franchisee is selling 1 million such burgers every year. Yeah, that's 1 million inches that are being reduced, and that's profit. Now, who suffers from all of this? Well, of course, it would be the franchisor in the US, because their reputation gets hurt. Now, let's say I'm the franchisee in Talon. I'm this Indian guy. I make some stuff in the restaurant. I sell it under the trademark McDonald's. And you go there to McDonald's, you eat over there and you get food poisoning. Nobody will say, oh yeah, it's that Indian franchisee of McDonald's USA who almost killed me. No, you won't say that. You will say, I went to McDonald's, I ate the food, I got sick. End of the story. So of course, you have to have quality control, which is very important. So franchising can have its pros and cons. So of course, it's easy money. That's how McDonald's, for example, Subway, all these other restaurant chains have been able to expand globally. You just sit back in America and count the money, because your franchise operations are now paying for themselves. But of course, it's not always straightforward and easy. So now that you have a trademark on the register of trademarks, can it be removed from the trademark register? Well, that's always an issue with trademarks, all sorts of IPR. Just because your trademark gets registered, there's no guarantee that it's there forever. It can also be unregistered. It can be removed, and there are a couple of ways it can happen. So you have to be very careful about these ways. And well, I'll talk about this. So this is not so much in the lecture notes. That's over here. The UK booklet. You can read about that over here, but I would rather prefer now to go to lecture 4 in the Moodle notes, which are also important from the exam point of view, where I've explained in greater detail all these requirements. So the national registration procedure we have seen, and how a mark can cease to be a registered trademark. Well, there are 4 ways. One is it is invalid. Now that's a very serious accusation. Basically, somebody is saying your trademark should never have been registered in the first place. It was all a big mistake or a misunderstanding. Very, very serious. Revocation could be, well, you don't use your trademark regularly. You're supposed to have genuine use within a 5-year period. If you get a trademark registered, you have to use it within 5 years. If you don't use it, then basically you can lose your registration, and the trademark may have become generic or misleading. So again, these are situations to be careful about. Thirdly, as I spoke about the Ford Model T or the Toyota Corolla, well, if you're not using the trademark, you can just surrender it, give it back, and that's the end of it. And of course, expiry is if the trademark has expired and not been renewed. And that was the Sandvik example I gave you from my own personal experience. So what is lack of genuine use? Well, you can read about this over here. There are some case laws as well, but you have to be very careful. In one situation, for example, the trademark owner had a trademark, the La Mer trademark case, for the goods, but they didn't really have any sales. And when they were really pressed to show sales, they just managed to show that they had done some 5 shipments in 6 months, and they had sold goods worth 800 pounds. That's ridiculous, right? That's 950 euros or something. That's not really a sale in the right sense. So what's happening here, of course, is a bit more sinister. Basically, you have a trademark, you're not using it, so you're just trying to forge some documents and try to claim that you have some nominal use, which you don't really have. And this can be very tricky because forgery is an art. Yeah, you have to be very careful about these things. You shouldn't think that you are the only smart person in the world. And if you make, just print out some sheets and say that yes, I've sold 1 million euros worth of products in the last 5 years, then comes the question, have you paid tax, VAT? All of these situations arise, and of course you have to be very careful. This is, remember, the trademark office. It's a government office. If there are any problems, they will complain to the tax department or whoever, and then you can get in serious trouble. So you have to be very careful about this. There could, of course, be proper reasons for non-use, and one example would be, now Marlboro cigarettes. Well, you don't see the ads anymore because most tobacco advertising has been banned. You also have rules in many countries, for example in Ireland especially, where there were these new rules about 2 years ago, 3 years ago, that if you have a cigarette packet, it should not have a trademark on it or a label mark on it, because they felt that peer pressure makes young people smoke cigarettes. So instead you should have this ugly photo of somebody with cancer or something. So you have these sort of situations where a trademark owner has a trademark, but they really can't use it because the law doesn't allow them to be used. And so, of course, in this situation, your 5-year non-use can be okay. There are also some other examples which you can see in the notes, and you have to be very careful about them. Then about misleading trademarks, there was this one situation where there was this family in Russia. They were making Smirnoff vodka for the Tsar, 150 years ago. And of course, during the Russian Revolution, they had to run away, and so the business went kaput. So a few, maybe 50 years later, somebody in the UK started selling vodka and called it Smirnoff. And of course, it's now a very popular vodka brand. And when you buy it, it has a Russian sounding name, but it's a British company. The trademark is owned by them, and they are not Russian in any way. So one heir family member of the Smirnoff family woke up and said in court in 2006 that, well, I'm from the Smirnoff family and this is my name and this is our family trademark. We used to make vodka, and this British company is misleading customers and they are buying vodka thinking it is Russian vodka, and it's not. And when this matter went to court, then Smirnoff UK was able to prove that this is not really the case, and of course we are not a Russian company. We are a UK British based company, and we don't know what this guy is talking about. None of our customers are being misled or anything at all. So that's the whole issue with trademarks. And then of course you can have also co-ownership of trademarks. So I've spoken about assignments, I've spoken about sales, and these are things to be careful about. So you can read about them more in the notes. Now lastly comes infringement and passing off. So maybe I could talk a bit about this aspect. Now if it's trademarks, you have two options, just like with copyrights and other forms of IPR. You can go under criminal law or under civil law. Now criminal law would mean you go to a police station and you say, well, I have a trademark and it's being misused, and of course it's a criminal offense. You can get 3 years punishment for that, and a lot of this happens because of organized crime. You see a lot of mafia organizations deal with counterfeit products because it's easy money. The police are not really interested in fake Louis Vuitton purses or something. They have bigger problems. There's terrorism, there's rape, murder, all sorts of nasty things happening, and they're not really worried about your fake Gucci belt or something. All right, so it's a low priority aspect. And just to illustrate about this, well, there was this one situation. Viagra tablets were being sold in pubs in London, And there are these blue color tablets, and Scotland Yard got involved, the London police got involved, and they found out that these were fake tablets. They were just made of chalk blue color powder or something. They didn't hurt anybody, but they didn't work. Now Pfizer's Viagra, if you remember, is a scheduled drug. It can only be sold on a doctor's prescription, and it can only be sold in a pharmacy. So of course these are huge problem areas, and so Pfizer wanted to take action about this, and because they're an American company, so the FBI got involved. It's an international issue, so Interpol got involved, and they found out through their sources that the factory from where all this fake stuff was coming was somewhere in South India. So now the Indian federal police got involved, and because we were the law firm for Pfizer, so we were handling this matter. Now we don't like police stuff because police stuff can be quite tricky. You have to coordinate with different agencies and deal with these things. But client said we have to do it, so okay. And so we coordinated with the Indian police at the federal level and at the state level. And so a raid was conducted on a particular day, and the godown was empty, the factory was empty, there was nothing there. So obviously somebody had tipped off the people, and now all these allegations of corruption and negligence started out, and that can be very unpleasant, especially when you have multiple agencies in an international setup dealing with this. So a lot of at least lawyers prefer civil litigation. You go to a court of law, you fight your case in a civilized manner, and whoever the defendant is, they have to pay a fine, the products can be seized, and the process is smooth and not a problem at all. So how does it work? You come to know that somebody is misusing your client's trademark, you send them a notice, you tell them stop doing it. If they don't stop, then you go to a court of law. There are some jurisdiction requirements and things to be careful about. And then you file the lawsuit in the court, and you say, well, I am the owner of the trademark, this is my registration number, these are my sales, these are the years I've been doing all this stuff, and this is my profit, and these people are misusing my trademark. Under the law, I have the right to stop them from using it. I have a certificate from the trademark office, and based on that, then you can ask for injunction so that the other side cannot sell this fake product anymore. Then they have to deliver all these products to you so that you can destroy them. They have to pay you a fine for all the damages. Then they have to apologize to you. There are permanent injunctions, temporary injunctions, because this lawsuit could take a lot of time, 5 months, 2 years. So you have this whole process. So it's about infringement and passing off, which you can see also in the notes. And of course, the provisions are quite identical to the provisions which dealt with relative grounds for refusal, remember, of trademarks. You have a prior trademark, so your trademark and the other party's trademark and the goods or services are either identical, or the trademarks are similar and the goods or services are similar. So there are some cases on that. Or the trademarks are similar but the goods or services are completely different, in which case it's a well-known trademark. And so these are the examples laid down, and of course you have to be careful about them. The only thing to keep in mind is used in the course of trade. So if you're just doing a one-off thing, it's not bad or illegal. But if you're making 1,000, 5,000, 10,000 t-shirts with fake names on them, then of course it's a huge problem because it's for commercial purposes. So these are some of the points to be careful about. And well, this covers trademark law. There are some notes in Moodle that you can read. But again, from the exam point of view, just keep in mind that there are 3 documents that you have to read for trademarks, and you will understand whatever is required. So that's it for today, and thank you for your time. Next week, we will start with copyright law, and I'll explore the various issues that can arise with copyrights. So thank you for your time and have a nice week. Bye.